Good evening, I'm Marty Olson and welcome to City Focus. Tonight we are going to move beyond our local realm in discussions of city charter, and we're going to expand our discussion to constitutional issues. Second Amendment in particular. It's certainly been a hot button topic over the last few months. And I've got two guests. We're all New London guys, but we're going to be talking about a global issue, I would say. I've got Scott Ennis and attorney Scott Camassar. Scott is the founder of the Disabled Americans for Firearms Rights, and he's represented by attorney Camassar, who I've known for a few years through our association in BNI.
Correct.
So welcome, gentlemen, and
Thank you.
Thank you. Yes.
Thanks for having us.
and this was put together kind of on the fly last night, and I'm tickled to have you guys in. I think we got a good topic to discuss, and it's something where I'm looking forward to learning, because it's not. I mean, I'm not a gun guy, quite frankly, and so it's an opportunity for me to learn, and I like that. So why don't you give Scott Ennis an overview of what's going on? You have filed suit regarding the recently passed state legislation, correct?
Correct.
And if I'm not mistaken, you were the first to challenge it.
Yes, we're the first to challenge the lawsuit. Yeah, you're correct.
I don't know if anybody else has jumped on board since, but you were the first guys to step up and say that you think that there's some issues here. So try to give us an outline of your organization. And I was shocked when I looked at some material you forwarded to me that you've got over 14,000 individuals nationally that are members of this organization. So we're not dealing with a tiny little local thing here. We're operating out of a den.
Yes, that's one way to put it. But yeah, we have actually now, the numbers are even higher there. I can safely say 15,000 nationwide, and I safely say 2,700, between 2,700 and 3,000 just in Connecticut. The organization was founded about June or July 2012, and it wasn't founded upon anything to do with legislative action or anything to do with like laws in general. It was founded on the premise of to show a person with disabilities so they can do the right to bear arms. So they didn't, so they didn't know. A lot of disabled individuals didn't know they even had the opportunity. So we kind of brought that to them. That was what we were originally founded upon. And then we kind of grew after that. We noticed a lot of guys coming back from Afghanistan and Iraq, disabled individuals that are veterans, and we wanted to give them an outlet where they can kind of do shooting sports competitions and keep that going for them. And we just kind of grew from there.
How old is the organization?
It's only been around since June, July 2012. It wasn't until we didn't grow that fast. We didn't grow like overnight. Well, actually, we did grow overnight. We didn't. It took a while to kind of formulate, but really the whole thing grew right around the tragedy in Sandy Hook.
Now, with the suit that we'll be discussing, I mean, did your membership, or is there a board or an executive board that had to authorize this, or is this something that, how did this kind of materialize?
I contacted Scott. Well, I started testifying in Hartford when all the legislation was getting passed around, thrown around. That's when our membership kind of exploded. At the time, I knew Scott for a long time, since high school. At the time, I was talking to him about legislation, about things that we were testifying, and concerns that I had, or concerns that our membership had, and that's pretty much, we went from there. We kind of saw the writing on the wall, as Sarah likes to say, but we knew something was going to come about. You could just kind of feel it whenever they were testifying that some kind of law was going to be passed, so we kind of prepared for it since then.
Now, the word disabled can mean a lot of things. It can mean you've got a broken arm, you've got internal issues. I mean, you get a whole mental issues. There's a whole variety of disabilities. Can you break down what your organization's representing, or is it kind of a catch-all?
Well, most of the things we represent are physical disabilities, such as different forms of paralysis, different forms of muscle disorders, things that are physically disability to a person. So, like arthritis, severe arthritis, like myself, severe joint damage from bleeding over the years with hemophilia. That's personally my issue. But we have a lot of guys that come back from Iraq, like one arm, one leg, just really, really, really. We wanted to do something for them, and that was it was almost like there was nothing for them. So we kind of started this, and that's where we kind of grew from there.
Okay. Folks, I would like to remind you, as virtually always, we're live tonight, so if you'd like to get in on the conversation, please feel free to give us a call, and the numbers are on the screen. And locally, we can be reached at 860-440-3154. Or if you're out of the local area, you can contact us at 1-800-253-2285. Scott, to my right. At what point have you come into this process, and perhaps you can discuss what you sent me here regarding this this suit, which names Governor Malloy as the first defendant, and what exactly are you hoping to accomplish? I mean, what was done, and why are you doing this? Let's put it that way.
Well, you know, when I was contacted, I think I want to say it was probably January. You know, Scott had come to me, and you know, in the aftermath of the Newtown tragedy, it looked pretty clear that the legislature was poised to you know, do something in reaction to that. In particular, expanding the assault weapons ban that Connecticut's had since, I think, 1993. And Scott's main concern was that the semi-automatic rifles that he and other disabled folks like him primarily use for shooting looked like they were going to be on the chopping block in terms of what the governor...
What do you mean by for shooting? What does that mean?
Well, it's basically any lawful purpose, hunting, target shooting, or recreational shooting, self-defense, you know, in terms of home defense and that kind of thing. And the reason that Scott was concerned was because the features of the so-called assault weapons that we're talking about are basically the pistol grip, the forward vertical grip, and the adjustable stock, so that he said, look, these are the kinds of things that I need to be able to safely and effectively use a rifle. There's, you know, loads of people in the same position that I'm in, and frankly, I had never thought about that. You know, because I know how to shoot. I don't have any physical problem. So it's really nothing that I, frankly, had even really considered. So, as Scott mentioned, he went up and testified a number of times at the legislature. You know, there were certain gun bills that the legislature held hearings on. The law that ultimately became Public Act 13.3, the Senate Bill 1160, which was this the law that was enacted. They actually, of course, as you know, didn't have a public hearing on that because it was an emergency certified type of situation. But you know, we felt that the expansion of the assault weapons ban, to the extent that it outlaws these kinds of rifles that are functionally no different than any other semi-automatic rifle, that it basically goes too far. And so our lawsuit is called an action for declaratory judgment. It's not a lawsuit looking for money. What we're looking for is for the court to declare the law unconstitutional. And the grounds that we're citing are basically that the language of the bill has a discriminatory impact on people like Scott.
Now, one thing we mentioned at the top, and you just outlined too, we're dealing with a constitutional issue. We do have a call, which we'll get to very shortly, so please be patient. But you filed in state of Connecticut Superior Court, and I mean, why isn't this a federal issue?
Well, it could have been, except we didn't frame it that way. And we talked about that, and actually this was our choice was to basically proceed under state law and raise only state constitutional claims. You mentioned the Second Amendment before. The federal Constitution, the right to keep and bear arms. We don't even mention that in our lawsuit. What we cite in ours is the right under our state Constitution, Article 1, Section 15, which clearly says every citizen has a right to bear arms in defense of himself and the state. So it's even more clear, I think, than even the language of the Second Amendment. But we're citing state constitutional and statutory law, and the claim is basically that this fundamental right exists, the right to self-defense, that state law also prohibits deprivation of civil rights on the basis of physical disability, and that the language of the law, to the extent that it outlaws certain firearms and certain features of firearms, prevents folks like Scott from being able to exercise that right, and that therefore it's unconstitutional.
Okay. Let's go to the phones. Good evening, and you're on the air.
Good evening, Marty. I wish your two guests would get a hold of a replica of a banned gun and a similar semi-automatic replica to show people visually what the difference is, and because it's cosmetic differences, and the one that a person that has a disability or a handicap can use is very, very helpful. I know you're going to dig out a picture, but usually on TV you can't. There you go. I give that.
Well, we're trying, Clark.
I didn't want to walk in with an AR-15, especially right now.
No, you're right. I meant a replica, not a real. But I think you ought to get that picture up, because it really illustrates the cosmetic differences, and the fact that one, a person that has any kind of a handicap can't really use, and the other one is much easier to use, and that's the crux of the argument, I think. Very, very informative show, but I do have one question. Why are the three people in this town that are all in the gun issue are all named Scott?
we get that question a lot.
Okay. Nice talking to you. Bye-bye.
Thank you for the call. And I suspect that maybe when you make another appearance, be it here or maybe on another program, that maybe you might want to bring that prop.
It's not a bad idea.
Yeah.
Not a bad idea.
For consideration.
Sure.
But based upon some of the callers' question, are we looking at a very narrow issue here in regards to the new law, or is this something that can be extrapolated out and involve basically all gun owners?
Well, I think both. I mean, it is, technically it is a narrow issue in terms of whether it violates this provision of the Constitution, whether it violates this particular statute. That's a very narrow legal issue. But at the same time, if it discriminates against disabled people, it has the effect and is invalid for that reason. It's invalid as to everybody. In other words, I don't think this is a situation where the court would basically say, you're right, Scott, we agree with you. We're going to give you an exception for disabled people, and they can get a handicap sticker. I don't think that's the situation we're talking about. It's either the court's either going to say yes, it's unconstitutional, or no, and it'll affect everybody the same way.
Now let's just for conversation's sake. Assume. I mean, I've got an economics background. There's a lot of assumptions in economics. Otherwise, it doesn't work. And that is that you were unsuccessful in this quest. What's next? Do you take your ball and go home, or do you appeal? Is this something that could make its way up to the Supreme Court of the United States?
Well, I think certainly. We'd have to analyze, the decision of the trial court. you know, in order to make an informed decision on whether to take it to the next level or not. I mean, certainly, you know, this is not a slam dunk. I mean, certainly, I think that we're right, and I think that we have good arguments, but it's an uphill battle in that, you know, the laws are presumed to be constitutional. Okay, and the person challenging the law has a heavy burden to demonstrate that it's not constitutional, and so. As the Attorney General's office has already commented and likes to point out, other people have already challenged the prior assault weapons ban and were unsuccessful. But that case is you know, distinguishable from our situation.
Was that in Connecticut?
That was. You know, after the initial ban was passed in 1993, some folks challenged it. It was a gun seller, and there were a couple of plaintiffs, but it wasn't a situation of a private citizen saying, hey, you know, the effect of this law means that I can't defend myself anymore. It was not that situation, and so, and for some other reasons, I think that we're talking about a very different case here. So I think we have a much stronger legal position than our predecessors did the last time they tried this. So, although I feel confident, you know, like you said, I mean, you know, nothing's a given, and you know, we have to be put on the best case that we can, and you know, if we're not successful, we'll have to, you know, make a decision at that point whether to pursue it or not. I mean, just sitting here right now, I feel like if we lost, that we would. I can tell you that if we won, that the state would most certainly appeal it, but you know, it's a different situation. So we'll just have to kind of wait and see. It'll be some time before there's a decision. So we've got a lot of work to do between now and then.
I knew this would happen here. One time I don't turn it off, I leave it phone.
Well, at least it was your phone and
That's
not
right,
mine.
not mine.
And I know better. I've been doing this for a long time.
It's your show. You could do it, though, I guess.
Let's see now. This suit was filed very, relatively recently, correct?
Correct.
So let's kind of get an overview of the timeline here. I mean, so the suit is filed. Last week you were on a Murray Renshaw's program.
That's right.
Tonight you're on my program. So you're trying to get your message out, what your case is about, and what this is, and what benefit is there to doing that? I mean, is this going to do anything in the eyes of the law, or is this the eyes of the public opinion?
Well, as far as I'm concerned, the benefit is to make people aware. I really truly believe that most individuals don't even realize that there is an issue with disabled individuals and firearms. It's just that way. It's just naturally, that's just the way it is. Actually, a prime example is, like I said, I've been up to Hartford numerous times, testify at the Legislative Office Building, 6 or 7 times.
On this topic in particular,
on this topic
or gun issues in general?
On this topic in particular. Also, before the public hearings, I actually met privately with a number of state representatives and senators to bring this to their attention, and 99.9% of them had no idea, and the other 0.1% kind of just had no idea and gave you the blank stare. They didn't know what to think. So it was our goal to, at least my goal was, and our organization's goal is to make this more known, and to get the word out there, because like I said, people just don't realize it. It affects a lot of people. They think that. A prime example of this is I was at the Key Issue Forum with Mike Lawler, and this question was asked to Mike Lawler by the moderator. Do you realize that this affects disabled individuals? And his answer was yes, he had heard that because we had actually sent him some stuff, but his answer also had the added answer of he'd be willing to bet there was other firearms out there that disabled individuals can use. And that very well might be true, that there might very well be named firearms out there that are not on the banned list. But the problem is the new law also makes illegal the options that we're talking about. And because of that, it makes every firearm that a disabled individual can use illegal, no matter if they name the firearm or make and model or not. And that's the big problem we have. So that's why we want to make the awareness.
Now, when this issue was being debated in the legislature, did your organization testify? And were you testifying in and of itself, or were you like a subset of the NRA? Did the NRA, have they taken up your cause? And the reason I asked the question is anytime guns come up, the NRA comes up. I mean,
well, not every time, and not every time, and I'll explain why in a second. No, the NRA, I am personally a member of the NRA. I've been for many years. I'm a lifetime member. Like I said, I've been shooting since I was 10 years old, so you're talking 30 years. So I've been an NRA member since Boy Scouts, actually. I'm also a member of Connecticut Citizens Defense League. But the NRA does not back us in any way. They are not tied to this lawsuit in any way. They do not help us financially or in any way at all whatsoever pertaining to this lawsuit or our organization. I have been on their news program 2 or 3 times, but other than that, we have no workings with the NRA at all.
If they want to send a check, you'd probably
exactly.
cash it.
If they would like to send a check, we would cash it, and we would definitely accept that. But no, we
pay the order of attorneys at Camassar.
That's right. That's right.
But what if any, lobbying have you done? I mean, it's not unheard of to have lobbyists that take up your cause in Hartford.
I have been the lobbyist. Like I said, I've testified 6 or 7 times. Every time there was a hearing, I was there.
As a private citizen?
As a private citizen and the founder and president of Disabled Americans with Firearms Rights.
Because, I mean, you're not a registered lobbyist.
Not a registered lobbyist because we're not collecting money for lobbying.
You're not a PAC?
No, not a PAC at all, no. We don't collect any money for lobbying whatsoever.
Does the organization collect dues? Is there any sort of...
No, the membership is completely free. We collect no dues.
I think these are important things to
put
out in the open here, just so everybody understands precisely where you're coming from.
Very much so. Yes.
I want to get back to the timeline, because before we came on the air, I broached that with you, Scott. And, the wheels of justice don't always move at warp speed.
No, they move rather slowly, and it's hard to say what the timeline will be. I mean, in part, that depends on how complicated or not the suit becomes. For example, whether we have to do a certain amount of what's called discovery, which is depositions and things like that, fleshing out factual issues. That will depend in part on the Attorney General's response. I mean, the next step in the lawsuit after we file it.
And they've got a couple of weeks before they
have
to.
They don't have to respond just yet. Beginning of May is the time frame, and they will file an answer to the lawsuit, admitting or denying the various allegations that we've made. And I certainly don't expect them to admit, certain of our allegations, such as that the law is discriminatory and so forth. So depending on their answer, that will help us focus in on the issues that we need to fight about. And I think what we're going to primarily be fighting about is whether and to what extent these types of features, the various grips and other adjustable features of these rifles, whether that is something that disabled people actually need to be able to shoot, or whether they have other reasonably available alternatives. That's going to be a big issue. And that'll involve fact witnesses, perhaps expert witnesses. There'll be legal briefs and a decision, and that the end result decision is probably over a year from now. So
Are you at liberty to discuss the specific points in here, or?
Well, I don't see why not. It's our complaint.
Yeah.
I mean,
Well, I mean, just from a legal point of view, if it's in your best interest or not, I'm not trying to compromise you here. I want.
yeah,
this
no,
to
I
be-
mean that's a fair question. I mean,
I don't know if you have it memorized, but I mean. That's
No. If you asked me something that I thought we probably shouldn't comment on publicly, then I would tell you that. But I mean, I don't think that there's really anything in there that's not true. I mean, certainly not anything. I mean, everything in there is true, and I can certainly try to flesh out any questions you have. But there's really no secrets here. I mean, the law says what it says, and the facts are what they are, and so the governor and legislature may disagree with certain of our contentions, and then we'll fight about it.
It's part of the system.
Exactly.
That's
But
right.
but like I said, there's nothing that there's really no secrets here. So ask away.
Okay.
Yeah, definitely.
Before we do that, though, we get another call. So
Okay.
we're going to go right to the phones.
Very good.
Good evening, and you're on the air.
Hi, Marty. I really like your shows have been wonderful lately, I must add.
Well, thank you.
And I just said to Mary Jane, am I delirious, or did I see these two people last week? Is this a taped show? And she said, oh, no, they were on Murray. I wanted to just comment on PBS. Oh, now my dog. Boston.
Told you it's
On
live.
PBS,
okay.
there was a program about gun violence, and they focused on Canada. And Canada, just about, they said, I thought really it was like 1 out of 3 owned a gun. And in Montreal, some of the big cities, people don't even lock their doors.
Yeah.
Their news is mostly happy. The crime, there's no crime rate. So I think it's not, I used to be more, bottom line, we got to get rid of the guns because we got so many crazies, but it really is the person behind the gun.
Yeah.
And now listening
That's
to
right.
these two, you got the most defenseless people, disabled people, who can't defend themselves now.
Yeah.
I mean, what, you have a taser and mace? That's
Can't even have a taser. They
ridiculous.
had a
They are
gun.
the most defenseless people, and they should have every right under the law, as anybody else. And this does come down to our Constitution. And I wouldn't be surprised if this goes all the way to the Supreme Court. And I will tell you, don't hold your breath as far as a year, because I went 7 years with the Catholic Church, and it took 8 weeks to pick a jury. And we didn't even have a full jury, and we had to start. And the church spent millions of dollars. I just wanted to be able to pay for my own medical. It was an incident. I had been scarred, and then I read in the paper today that they're getting pro bono work, $100,000 from legal aid for the soup kitchen. They've got money up to zing-zang. Leave that money for the indigent. That just angered me. Pro bono work for one of the most, the richest. It's a corporation. I mean, the Vatican made a deal with Hitler not to invade because they had all of their artwork and all of this and all of that. It just makes me crazy. But I hope that you guys do well, because, I mean, you're picking on the weakest, the meekest, and you're taking a right, and then, how do you say that? An inalienable right?
Yep,
Yeah,
that's
yeah,
it.
we're-
Away, and that's very scary. Very scary.
She makes some excellent
So,
points.
Excellent point.
I'll shut up and I'll listen to you, Marty, but you've had some great shows lately. Thank you.
Well, thank you very much, and we'll keep trying to have good shows. I would like to get into the
Sure.
body of this suit, because that'll help, I think, offer a little clarity to precisely what we're talking about here.
Yeah, sure. But before we do that, Marty, if I could just make
You wanna
make one
make some-
comment.
yeah.
In relation to that last call. The point that she made about the disabled people being among the most vulnerable in society. I mean, I agree with that, and that's one of the reasons why I feel so strongly about about this case and why I took it. I mean, I didn't just take it because Scott's been a friend of mine since we were in school, but you know, whether it's disabled folks, elderly folks, you know, people of small stature, even if they're not disabled, you know, small statured women, for example, are among the most vulnerable in our society. And you know, picking up the phone isn't simply an option a lot of times to call the police. You're your first line of defense. And so, so she makes a good point that, you know, the folks that are, you know, most vulnerable to violence, you know, need to be able to defend themselves. But in any event, I didn't want to. It's your show, so ask away.
Well, that's fine. I think that was important, and I'm pretty flexible here.
Good.
We're resilient, and we try to accommodate here.
Thank you.
But the suit is Disabled Americans for Firearms Rights, LLC, by and through its founder and managing member Scott A. Ennis and Scott A. Ennis individually, versus Daniel P. Malloy, Governor of the State of Connecticut. So that's who's suing who.
Correct.
And it's a complaint for declaratory judgment and injunctive relief.
Right.
Okay. Hope we don't get bogged down in too much legalese here, but we'll do.
I tried to keep it simple.
That's pretty simple. That's pretty straightforward.
First count, number one. The plaintiff, Scott A. Ennis, is a resident of New London, Connecticut, and brings this action for declaratory judgment individually and on behalf of Disabled Americans for Firearms Rights, LLC, a limited liability company organized under the laws of the state of Connecticut, and its members, to vindicate the constitutional rights of citizens of Connecticut and to enjoin the defendants from enforcing an unconstitutional law described below. That's pretty self-explanatory.
I think so.
Yeah.
Number two, the plaintiff, Disabled Americans for Firearm Rights, LLC, hereinafter DAFR, founded by Mr. Ennis, is an organization composed of thousands of members throughout Connecticut and the nation, which has as its mission the education of the public and elected officials concerning the unique needs of disabled individuals when they exercise their fundamental rights and the lawful use of firearms, among other lawful activities. Again, I don't necessarily think that that's getting anybody too jazzed up yet.
Right.
Well, it's pretty straightforward.
Yeah, I mean, number three, the plaintiff, Scott A. Ennis, is a disabled individual who suffers from a medical condition known as hemophilia A bleeding disorder that has caused him severe joint damage, thereby impairing his physical strength, flexibility, and range of motion of his limbs, particularly his upper extremities. That kind of outlines precisely your issues.
Yep.
I want to emphasize, because this is a physical issue. You know,
Right.
I mean, one of the, you know, especially with all the stuff that's been going on, I mean, between Boston and Newtown and other, where discussions come up regarding folks who've got, you know, they've got issues mentally. I mean, that
Right.
they're not,
Yeah.
they've got issues that they're not functioning properly, and they,
Right.
and how do we discern that? And is that part of this?
Well, I don't think it is. I mean, you know, certainly, you know, and I hate to paint with a broad brush. I mean, there's plenty of, you know, people with a quote-unquote mental disability that, you know, may very well have, you know, no problem using a firearm and necessarily shouldn't be precluded. The people that I think we can all agree should not be using firearms or even have access to them are people who have a mental defect that make them a threat to themselves and others. And certainly every mass shooter that I can think of has been, you know, someone, you know, with some type of mental illness that makes them dangerous to themselves and others in society. So we can all agree that those people shouldn't, you know, shouldn't be using guns. You know, basically, and you're right, you know, as far as even physical disability, you know, that's a pretty broad term that can encompass any number of conditions. So I think if the question is, well, who do you, who are you including in this lawsuit? I think the best way to answer that is basically, everyone who had a physical disability that could lawfully engage in, lawfully use firearms prior to the enactment of this law, who now are restricted or precluded from doing that on account of the law. I mean, obviously, if you have no arms, I don't think that we can help you out with shooting a rifle. If you're blind, I don't think we can help you out here. But folks like Scott who have whether it's I mean, Scott's situation is he can't rotate his elbow or his wrist to hold a rifle in the traditional manner because he can't do this. So that's why he needs the grips that he can do this. Folks like that. That's who are encompassed in our suit.
Mm-hmm. Would somebody such as Ron Rando with Ron's Guns, I mean, he'd be somebody who would be an advocate for this, for you guys on something like this?
I think so.
I don't know if he is or not. I know Ron, and he has the gun shop out in Flanders. And
I think I haven't talked to him specifically, but he's a good friend of my dad's, and I know my dad's talked to him about it. And the information I got back was that he was in favor of what we're doing. So. Yeah.
This guy's a straight shooter, I'll tell you.
Yeah.
No pun intended. I mean,
I mean, a lot of folks, I think, are in favor of what we're doing. I mean, obviously, people who don't own guns, who have never used a gun, don't understand why anyone wants to have a gun. Those people aren't going to be in favor of what we're doing. People who...
And you recognize that.
And absolutely. I mean, there's no question. I mean, I'm sure a lot of people... read about this in the paper and either said, heck yeah, or they said, who are these idiots and what are they doing? And I'm fine with that. I don't expect everyone to agree with me necessarily. I don't even have to agree with him politically. I mean, there's no requirement that a lawyer agree with his client politically. I happen to. I think, I believe in what we're doing. But, I understand there's a lot of people that, aren't necessarily in favor of this. But, we think it's an important issue that needs to be discussed and decided.
Yeah, I mean, one thing I have found, and I've been involved in politics primarily locally for on and off for the better part of 25 years, and is that often the political class will respond to something that happens now, mm-hmm. even though there's a long laundry list of ordinances, statutes, and assorted laws and regulations on whatever it may be. And getting anything enforced is the million-dollar question to me. I mean, if you're going to have laws dealing with the guns, and I'm not a gun owner. I think the last time I picked up anything of that nature was Boy Scouts, and I'm older than you are, so it's a long time ago. But I can appreciate where you're coming from. And that's why I think adding more laws for the sake of just doing something. Are we accomplishing our real objective?
Well, I mean, certainly we don't think so. I mean, we. I know I speak for Scott when I say that we, share the goal of making society safer. This particular law, we're challenging, only certain parts of the gun provisions, but, this law should have been about, if we wanted to address the tragedy and try to respond to that in a meaningful way, it should have really, the focus should have been on improving our broken mental health system and school security. Mm-hmm. This kind of knee-jerk reaction, we got to do something and go after guns. It's easy politically, and it scores a lot of points, and it can be done quickly, as we see. This was kind of rushed through, but it doesn't do anything to make anybody safer, and that's the problem with it.
Okay, let's continue through here. We get to some more meaty stuff as we get through.
Sure.
But number 4 is the defendant, Daniel P. Malloy, is governor of the state of Connecticut and at all times relevant. Hereto was acting in the course and scope of his official duties. Number 5, the Connecticut Constitution guarantees certain fundamental rights of citizens of the state, including the right to bear arms in defense of oneself and the state. Is
right.
the Connecticut Constitution mirror the United States Constitution, or is it some derivation thereof?
It's similar in many respects, but that, as I mentioned earlier, that's a reference to Article 1, Section 15, the right to bear arms under the Connecticut Constitution. There's also the Second Amendment in the federal Constitution, but the language of ours is actually stronger and less ambiguous.
So they don't, and Connecticut doesn't mention militia or anything along those lines?
No. I mean, we do have a militia statute, actually, and the militia is basically, well, there's really two types. There's the organized militia, which is like the National Guard, and then there's the unorganized militia, which is everybody else. You're the militia, I'm the militia. People don't realize that they're in the militia, but they are. And so there is a militia statute, but the constitutional provision does not make any reference to the militia. Mm-hmm. Refers only to individuals.
Okay. Number 6, the laws of the state of Connecticut also prohibit the deprivation of civil rights on the basis of physical disability.
Right.
Yep.
And that was something that, not necessarily in Connecticut, but federally, was, Lowell Weicker was a big proponent of, through ADA.
Right. No, I mean, there's, the Connecticut Constitution, Amendment 21, and state statutes make it clear you cannot discriminate on the basis of disability.
And continuing, the fundamental rights guaranteed by Article 1 of the Connecticut Constitution include the civil rights that may not be denied based on one's physical disability.
Correct.
That kind of reinforces what you just said.
Yep.
Number 8, on April 4th, 2013, Governor Malloy signed into law Bill number 1160, an act concerning gun violence prevention and children's safety, now known as Public Act 13-3. The act, in response to the mass shooting at Sandy Hook Elementary School in Newtown, Connecticut, 4 months earlier. So that kind of outlines why that law was
Right. That's just
done.
background, basically.
Yeah. Now, is this what you would call a brief, just for legalese or no?
No, that's a complaint, which is the word that refers to the lawsuit itself. And legal briefs are basically, once we have the issues that we're fighting about, I'll write a memorandum of law citing all the legal authorities, and the state will do the same thing. Those are called briefs, but they're not necessarily brief. They could be fairly lengthy, but
Yeah.
Okay, we're getting hit with a couple of calls here, so let's go to the
Very
phones. Good evening, and you're on the air.
That is a visa call. That's why you weren't told it's yours. Take number 2, please.
Hello?
And I'll do that, and we'll take call line number 2. Good evening, and you're on the air.
Yes, good evening. I just want to say what a great show. I'm glad that you guys took time to explain what is in the suit, because at first I didn't understand where you was coming from. So just want to, I don't want to hold you up because I would like to hear more about it. So just want to say good job.
thank you.
Thank you very much.
Thank you for the call.
Okay.
Let's see. Number 9, the Act makes substantial changes to existing firearms laws, including an expanded ban on certain firearms deemed to be quote-unquote assault weapons, identified the Act by specific model name and manufacturer, or by reference to certain enumerated cosmetic features, such as hand grips and adjustable stocks. The law also restricts quote-unquote large capacity magazines. So now you're more clearly identifying where your issue is.
Right. And I don't know if it's in the next paragraph or the following. We actually quote some of the statutory language. I'm not sure you want to read all that into the out loud, but in any event, we do cite the specific language that we're concerned about.
Yeah, I mean, I am a little bit surprised to see a state law get so specific. I'm more accustomed to seeing laws more on the ambiguous side, feeding the attorneys some work to kind of massage it. And
Well, it's a balance, I mean, particularly with criminal statutes. I mean, there has to be a certain amount of specificity, because if it's too ambiguous, it's going to be void. It's going to be void for vagueness, basically. It can't be so vague that you don't know what it's prohibiting. I mean, the general rule is that for a criminal law like this, a person of average intelligence needs to be able to look at the law, read it, and understand what's allowed and what's not. And I'll tell you, this law is almost incomprehensible in places. I mean, it's 180 pages. I mean, the minutia, your head spins, trying to figure it out. And I'm not sure I understand all of it. I mean, in fact, I'm pretty sure that I don't. But so I think there's a lot of provisions that are a problem. We're only focusing on a couple, but the law is frankly a mess.
Well, let's continue here. We've got about 5-10 minutes left in the program, folks, and if you'd like to chime in with some thoughts or comments, questions, please do. The program is live, and I'm Marty Olson at City Focus with Scott Ennis and attorney Scott Camassar. And we've had a really, I think, an engaging conversation this evening on an important topic. So I want to thank you guys for coming in here.
Thanks for having
us.
And the number you can reach that locally is 860-440-3154. Or if you're outside of the local area, you can reach us at 800-253-2285. Moving along, among the now banned firearms is the AR-15. Is AR assault rifle? Is that it?
No, it's actually an abbreviation for Armalite Model 15.
So see what I know about this stuff.
Well, a lot of people.
You guys in here.
A lot of people make that assumption, but see, that's where a lot of people are confused. Assault rifle. There is such a thing as an assault rifle. An assault rifle is defined by federal law as a fully automatic machine gun that's used by our military. That's an assault rifle. Assault weapon is a political term that was made up by certain politicians and others to basically confuse the general populace, particularly those who don't know anything about guns.
Politicians do that?
Well, some I think have been known to do that, but certainly not you and people of your ilk. But there are some that aren't necessarily.
I'm not smart enough to do that. I
know.
Straight, you see.
But a lot of people, including someone on one of the mainstream news stations I was watching during the Boston the manhunt for the terrorists the other night, are using the term automatic and semi-automatic interchangeably, and they're not. A semi-automatic rifle like the AR-15 and any other semi-automatic weapon that we're talking about is one bullet per pull of the trigger. You cannot. They don't spray bullets. I mean, there's a lot of people that just have no idea. And so assault weapon is really a meaningless term that is used to describe all types of semi-automatic firearms. And the reality is the ones that are banned by this law function no differently than any other semi-automatic handgun or rifle.
Okay, we got another call. Good evening, and you're on the air.
Hi, Marty. It's me again. I've been listening some more, and it just dawned on me. What about all of the vets, Vietnam, Desert Storm, and the ones that are now coming home, many of them amputees, sent over to protect this country, then come back to this country and don't have the right to do what they were sent over to do there. They can't protect their wife, they can't protect their children, or if the men or women, or if they're not family. How does that make sense? And an assault weapon, that could be a street broom. I mean, for heaven's sakes, it could be a frying pan.
She's right.
I think he's right. You're gonna have a lot of poster boards, but it's just gonna take a few intelligent people to realize this spin, this awful spin that goes on with politicians, and it's a feel-good thing. And what's gonna happen is we're gonna be left defenseless, and the bad guys still have the guns.
Yeah.
And until they, getting into another topic, but maybe legalizing marijuana, which would help our country out of a huge deficit, that could be done too. But it just does. It seems crazy.
I'll have to bring in another guest for that particular show, but that's an interesting topic.
But you think about it, you get drafted, you're mandated to go fight for your country, and then you come home and you can't fight for your own life
That's a good point.
you're
very good
missing
point.
an arm or
Many of our
finger.
members.
That's a good point, and I think that what you've outlined is gets to the crux of what this is all about.
Yeah,
Yeah.
definitely.
I think it's a double standard.
Yeah.
Okay, thank you.
Thank you.
Thank you.
Again.
And I will say, I do believe that the Uzi made by the Israelis was is that correct?
I think so, but I'm not
Israelis?
positive.
I'm not sure, to be honest with you.
One of the best mechanical, if you ever looked at the design, it's ingenious. Not that I don't own an Uzi or anything, but
That's encouraging.
you ought to really sometime look at the blueprints of these things. They're ingenious, and they're made to save lives, not take lives. Thank you.
Thank you very much. Okay, well, we've kind of got the outline of this Armalite, which is actually in the next line here.
Right.
So that helps to define that. And many different terms of manufacturing, including Colt, which you mentioned, which is a Connecticut-based firm.
Right.
Although I'm
Unless they
wondering how
leave.
long that's going to be if,
Well,
if they're
if-
forced out of Connecticut.
Yeah.
A couple Connecticut companies.
But just to show you, I mean, Colt's been making this gun since 1959 here in Connecticut. And so this whole thing about crazy people using AR-15s to shoot up innocent people, it's a fairly recent phenomenon. I mean, that's a topic for another show, I guess.
Well, the next couple of paragraphs, you get into more detail regarding the AR-15.
Right.
In the number 13, you get into a bit more depth. We've only got a couple of minutes, and I'd like to just skip ahead here, because number 14, you get into disabled persons. And I think that's, considering who you're representing, then maybe this is something we ought to try to squeeze in here. Disabled persons, including the plaintiffs and members of DAFR, require adjustable or customizable firearms built on the AR-15 platform, or other semi-automatic weapons with certain of the prohibited features, such as pistol grips, forward grips, and folding or telescoping stocks, in order to safely and effectively exercise their fundamental right to bear arms, including participating in shooting sports, hunting, and lawful self-defense from criminal attack. The provisions of the Act unfairly and arbitrarily deny these fundamental rights to the plaintiffs, which I think it's really
That's basically it.
That's basically
that's
it in a
outlining
nutshell.
your case.
Right.
Yep.
Right. That's our claim. And we think it's important. The Connecticut Supreme Court has said that self-defense is the only constitutionally protected interest when it comes to guns, and it's our position that the law prohibits people like Scott from being able to do it. So that's why we're fighting.
That's right.
Well, I want to wish you guys success as this thing moves forward. And,
Thank you.
I thank you guys for coming on tonight. It's been a really good conversation, and I enjoyed our phone calls. They were, I think, productive and on target and on spot for the discussion at hand. And again, thank you, Scott Ennis.
Thank you for having us on, Marty. Thank you.
Scott Camassar.
Thank you.
Good to see
Appreciate
both of you
it.
guys.
You too.
Thank you.
And we'll be back next week. And I'm hoping to have the co-chairs of law on next week to discuss the City of New London budget. Get back to something a little more close to home. Thanks, folks, and good night.